We're discussing strategies to build generational wealth through real estate and estate planning. Good morning. I'm Jemea Kingsby at Mia Miami _ real estate. Today, I'm here with Sarah Bertrand at Bertrand Law Group, the managing partner of Bertrand Law Group, PLLC, in Miami, Florida. She specializes in real estate law and family law. Sarah, thank you so much for joining me today.
Thank you for having me, Jemea. I'm really happy to be here. I'm really happy to share information with everybody that's out there. I think we have some very interesting topics. I think we have some very good information that I'm really excited to get to everyone, some stuff that I'm sure a lot of people are interested in getting to know, especially in the times that we're living in, and a lot of stuff that we just don't hear about and don't know about. So.
Yeah, this is going to be a really great topic. I'm super excited about this. Before we jump into it, can you give us a little bit of background?
Sure. So, like you said, my name is Sarah, and I am a born and raised Miami native. I went to Miami Northern Senior High School. I went to University of Miami undergrad. I went to Nova Southeastern Law School. I'm a true South Florida girl. Born and raised, never left. So South Florida is my hometown. After I graduated from undergrad, I had an opportunity to work at a law firm. And from there, I decided that I really wanted to go into practicing law myself. So from there, I went and applied to law school and got in. And I've had a chance to work with a lot of different attorneys. And from there, I developed my love for real estate. And I really had a passion for that. So I do a lot of title work, a lot of real estate work. And then from personal experiences, I may look a little young. I'm just going to add that in for myself, but I've been through a divorce. So that's where my family experience comes through. I've had family members pass away. So that's where my estate planning part and, probate experience comes through. So a lot of stuff that I get to practice and do now is because I've had personal experiences from it. So I guess that gives me an ability to connect with the clients on that end and kind of walk them through the process and, let them know that, hey, I've been there and stuff. So I could kind of help them plan for certain things on a personal level, because I've also had that personal experience with those things too. So
that's an amazing journey, and to see that now you're using your own personal experience for the greater good. I love it. I absolutely love it.
Thank you.
Well, let's jump in. So, I'm excited to talk about this, but let's set the premise for everyone. As we're discussing generational wealth, we're not simply speaking about dollars in the bank. I truly believe that wealth is abundance of your family life, spirituality, your health, your mindset, and then also your financial assets. And in this conversation, we're going to focus on using real estate as a tool or an asset to build and sustain the wealth for your family and for your children and so on. How does someone purchasing a new home make sure that the home stays in their family?
Well, I think there's a couple of things. I think, and besides purchasing the home, it's important to kind of educate and make sure that the person that you're going to eventually leave the home to understands the value of what you're leaving to them and understands what you're going to be doing and the sacrifices that you're making to leave the home to them, and they understand the value of that asset and I guess what you're leaving it for them for. I see a lot of clients that come in and they've lost a home that has been left to them for tax reasons and stuff like that, or because there's too many siblings and the siblings can't decide what they want to do, and there was no plan for afterwards, and somebody is staying in the home and has decided not to pay or not make repairs, and then because nobody wants to take the responsibility, then they just kind of give up, and then the parent essentially left that home for them, but because no one is willing to step up to the plate, it's kind of been left in vain. So I get a lot of those cases, and a lot of times these properties were already paid off in full, and they're being lost for $20,000, $30,000, $50,000 for no reason. Just because siblings couldn't get along, or an aunt and uncle were not aware of what was going on, or because there was no plan, and people couldn't understand, or a spouse of a sibling gets involved, and it gets a bit messy. So I think it's important for people who are our age, who may have older parents, to kind of start having that conversation. with their parents in terms of, okay, what's the plan? What do you want me to do with this property? And for parents to, you know, let the children know, okay, you know, in the event that something happens to me, here's what I want you to do, and here's, you know, where I want you to go with this. I think that's a conversation that our community doesn't necessarily have, because we always expect that we have some time ahead of us.
Yeah.
And that's an issue that we need to kind of go ahead and start doing. The other side of that is legally having some paperwork that's already in place that kind of structures, okay, here's what happens. And that could be done in a couple of ways, whether it's on a deed or whether it's on putting the property in a trust. It allows for ease of passing the property along. A lot of times people, what we've been taught all our lives, or what we've known in the general sense, is about leaving a will. So, you know, for the most part, people may say, okay, you know, they've left a will, and they're in the will, they've left the house to their kids or their aunt or whatever. But what we're going to talk about today is how a will is nowhere near enough in terms of, not even a little bit of enough, like in terms of leaving property or passing property. A will is actually kind of problematic these days in terms of leaving property behind. So it's definitely important to have some safeguards in terms of leaving the property behind, and actual instructions, and possibly passing the property prior to, you know, to death, to ensure that, you know, it's properly cared for.
Okay. These are such important topics, and even just hearing, I think most people think, oh, if I have a will, and if they even have a will, that'll just take care of it. I don't have to worry about it. You know, people don't want to discuss the oncoming, but I mean, it's happening to everyone at some point. Let's address it head on. And the knowledge, having the knowledge is just the most important thing. Okay, so I guess let's break some of this down a bit further. Starting maybe with the deed. What are the right words to include on something like the deed to the home?
So say, for instance, they wanted to just have the deed as the vehicle to leave the property, and they weren't going to do anything else, and they wanted to do a deed. If it's between spouses, you know, a spouse would have what they would call a tenancy by entirety. So meaning that neither spouse could sell the property or do anything to the property without the other spouse. And then it has what's called a right of survivorship. So upon one of the spouses dying, the other spouse automatically is the one the property passes on to. So that is one way that avoids probate, and probate is going to court and having to pass on property, which is that is. So when you hear them have the term probate, it means that you have to go to court, and that's how the asset is passed on, or that's how the property is passed on, and the person who's supposed to receive the property or the asset, that's how they get it. You have to go to court to receive the property. Yes.
Okay.
And that's essentially what a will does. So when we'll backtrack a little bit. So when somebody leaves something to you in a will, the will is nice, but that will has to go to court, and for the judge to approve the will, which is the probate process, that's what we call probate. The judge has to approve the will in order for you to get what was left to you in the will. So it's not a simple process. It's not like, okay, hey, I'm leaving you this chair in this will, and okay, here's your chair. You have to actually probate the chair. Yes, and then from there, you know, so it's not like in the movies, you know, you just go and then the attorney is just like, okay,
go and collect your check.
Right. No. So before you get to the point where the attorney, is like, hey, here's your check. By that time, they've already been to court. They've already, that attorney has been named a personal representative. So they're the ones who are now executing and divvying up what the court has allowed after they've already taken out their fees, after they've already paid creditors, after they've already paid taxes, after they've been paid, you know, to be the representative. So it's already, you know, monies have already been taken out from the estate. Everything else has already been taken out that needed to be taken out. And that could be, you know, several years, especially if there's anybody who's contesting it. So that's that part. So if you are married, you're going to look for tenancies by the entirety. Say you're not married, say it's family members. So I say, for example, it may be, you know, two sisters who have a property together or something like that. And they want to, you know, the property is for either one of them, and they don't want the property to pass to anywhere else or anything like that. What you would look to do is have what you call joint tenancy with right of survivorship. So if something happens to either one of them, at that point, the property automatically passes to the other one, to the other sibling, or to the other person. So that avoids probate also. However, with that, what I've seen, for example, you can have a situation where, say for instance, if I have a property and I decide, you know what, let me add my sister onto my property afterwards, add her name, just in case something happens to me, I want her to be already on there. If I don't add it properly and I add her name afterwards, and then for some reason, God forbid, something happened to my sister, before something happened to me, I now have to go to court to have my sister's name removed from the property before I could do anything else with my property that I had. Yeah, exactly. Wow. That was already my property, right? And why did that happen? Because I added her name after the deed was already made instead of adding our names at the same time. So there's a lot of little intricacies. Yeah, there's a lot of little intricacies. So what could have avoided that little situation if when we were redoing the deed, we would have added our names together again.
Okay.
So but instead of me just
this is planning, this is all planning.
Exactly. So instead of me just adding her name, I should have added my name and her name together at the same time. And then it would have been joint tenancies with right of survivorship. And then once if something would have happened to her, I would have automatically received the property back free and clear. But now something happened to her and I have to go and pay an attorney, cost me money for my own property that I was just that I thought I was trying to safeguard, but now it's costing me a couple $1,000s and time to, go ahead and do it. So it's a lot of little things that, it's minor things that we don't necessarily know. And it's important to have like somebody to know these things and kind of explain them to you.
This is the importance right here of speaking with a professional to have that representation and that knowledge. I mean, I'm wondering, how can a family avoid the bank and the IRS from taking what was essentially generations of families' investment?
So, unfortunately, what we see is that a lot of our grandparents and older parents don't make a lot of money in retirement times, right? So they weren't able to properly plan for their retirement. So they get into these times where they're not able to work anymore. Their social security is not enough, but they still need money to live. And they were independent and they could have 10 kids and 50 grandkids and they don't want to rely on us. So they find their own means. They find their own means to remain independent as long as they can. And one of the lending tools that is out there is a reverse mortgage. And sometimes it seems like a great idea for them at the time, but in actuality, it's not the best tool for them to use, because what happens is that nothing is due while they're alive, right? So usually, so they could either get a lump sum or they could have payments sent to them because it's coming out of the equity of their home. Because they own the home, they're sending them payments out the equity. But what happens is when the person does pass away, now that money is due, right? Now the money is due. You have to pay the money back because they took it out. But if they didn't discuss it with their family members, like, hey guys, I'm taking out this money, but if something happens to me or when something happens to me, here's the plan of what you guys need to do. So now they're like, oh, okay, grandma passed away. We have the house. And then because like, hey, hold up, grandma took $100,000 money back.
Yeah.
What are we doing? And then now everybody's like, wait, what's going on here? Somebody has to pay them that money back because grandma was using the money, right? And obviously it doesn't need to be the whole family, but immediate family, like my mom, I should know, mom, okay, what are you doing? What's going on? Where's your stuff? Like I need to know these things. Like, you know what I mean? Like where's the papers? If something happens, like what am I supposed to do? What are your options at that point? For them to lose the house is another sign that nobody was communicating, because now what happens is you have 10 people or 5, 6 siblings, and everybody has their opinion on what they should do, what they should not do. My friend said do this, my other friend said don't do that, or let's do this, and then it becomes a lot. So you have a reverse mortgage. There probably wasn't a will. The house wasn't in a trust. There was no directions on what to do. So everybody has their own opinion. Tensions are high, and then everybody's like, you know what, forget it. And then this is how the house usually gets lost, because nobody wants to jump in and take responsibility with a calm mind, because everybody's already up in arms, and and then this is how the property gets lost. So what would have been some better options to avoid this? So the loan has to get repaid. Options were they could have decided altogether to sell the property, and paid back the loan, because I'm sure it was probably worth more than whatever the loan would have been.
Right.
And they could have taken those proceeds and divided it amongst the family, whatever was left. They could have kept the property and refinanced it and, taken out a different loan, which would have been a loan that would have repaid whatever they took out from that loan and paid off that lender. And then it would have been a regular loan. And then they could have, as a family, decided, okay, turn into a rental property or maybe an Airbnb, and the loan would have just kind of paid itself or whatever. But obviously somebody has to take the responsibility of, putting their credit on the line and doing all that other stuff. Another option also is deed in lieu. So if the property was completely, maybe say, upside down, and nobody had credit to refinance, and there was no money that was going to be left over in the foreclosure, if they would have sold it or anything else, you can deed the property over to the lender, and that's called a deed in lieu of foreclosure. The last option is just foreclosure. They foreclose on the property and they take the property over. So there's always a few other options. They could have short sold the property also and just, sold the property. And usually with the reverse mortgages, there's no default judgment. So even if the property would have sold for less than what they owed, nobody else would have been responsible for what was left over. The bank would have just taken whatever they could have got, and then that would have been the end of that. Once again, the issues that happen is because they didn't discuss with grandma while she was taking out the loan, and nobody knew. They probably didn't even know grandma took out the loan. They thought, okay, the house was fine. And, they come into this without a plan, without knowing, and then nobody was ready to talk about what's happening next.
Yeah, this is really, seriously, this is where passing on the wealth of knowledge becomes critical. Because even if your father, your grandfather, grandmother had the financial skills to pass along these assets, if the children and grandchildren never took the time to gain that knowledge, then they could really end up being the weakest link in their family's generational wealth.
And it went for nothing. Yeah.
For nothing. Yeah. This is something that children need to actually be taught, how this exactly works and what this plan is from younger ages. That's really serious. I'm curious now, what about like with the living trust? How does that work, or how does it kind of protect families down the line?
You always heard the term of like trust fund babies and things like that. So for us, I grew up thinking that, okay, trust fund is for, rich people.
I thought it was,
and there's like a way different tax bracket,
I don't know.
I don't know. You have to be a millionaire to have a trust and things like that. And that is absolutely not the case at all. I think anybody who owns any property should have their property in a trust. Like,
there it is. Repeat that, please.
If you own property, it should be in a trust. If you have a home, your home should be in a trust. Like, you should buy the house today and put it in a trust tomorrow, like automatically, no matter what.
Wow.
Like, you should not be holding on to the property at all, and in no way, no shape or form.
Wow.
And why? There's a couple of reasons. When you have a will, what the will does is it pretty much outlines what that person wants to happen with their property and their assets upon them passing away. In order for those people to get those things, you have to hire an attorney, you have to go to court, and the court has to say, okay, we approve this and that, okay, it can be passed on. That's if somebody doesn't come and say, hey, that will is not true, or hey, somebody, forged the signature, or hey, there's another will somewhere else, and hey, she wrote a will after that, and that's not the most recent will, so there's people contesting, or hey, they didn't mean to write the will that way. So there's a lot of issues, and you hear that all the time, people contesting wills, fighting over the will. They didn't think the will was right, or the person wasn't of sound mind, and they don't think, they thought the caregiver forged the will, and all of this stuff. So there's all of these issues that happen with the will. The will passes the property after you pass away, and the trust passes the property while you're still alive. But with the living trust, you get to still manage the property. So you're still in charge of the property and everything else. You sell it, you can still move it around, you can still do whatever you need to do with it. However, it's just in a trust. So what does that mean? That means that while it's in a trust, it accounts for if you pass away, if you become incapacitated, something happens to you, you already have someone in line as the next trustee, and you already have beneficiaries, and there's already directions as to what's going to happen to that to go ahead and manage everything else. So it avoids a lot of different things. So one of the things that the court usually does is, say for instance, you become incapacitated. Something happens, God forbid, you're in an accident, you're in a coma, you're in the hospital, and you have all these assets, bank accounts, and family needs to get to it and stuff like that, the court may order what's called conservatorship, which is where they try to protect your assets, and because people are trying to, you know, pay bills, and they need to pay for hospital bills, and they need to pay mortgage, and they need to pay this, and the court needs to like put a hold on it until they could figure out who's supposed to be in charge of what, who's supposed to be paying for what, and whatever else maybe. If you have all of these things in a trust, there's already a trustee that's named after you who would be in charge of managing all of these assets as well if something happens to you. So they already know, okay, this person is going to have directives on all of your medical stuff. They have directives on all of they have power of attorney over all of your accounts. They have power of attorney over all of your assets. So they already have, you know, pretty much a plan in place. So if something happens to you, they are the next in line to go ahead and manage, and they can disperse things to your beneficiaries. There's already a plan in place, and it's already passed on. So what does that do? That avoids you don't have to go to court after that, because there's no court. It's already, everything was already passed. Yeah.
Oh, why wouldn't
there's no court. There's right. So there's no court. There's no having to transfer assets. There's no having, because everything was already transferred. So it's already like you are managing it while it's here. Okay, if I'm not here no more, this is the next person to manage. All right, boom, here you go. Here's all the paperwork. Go ahead and take it on, and you know, it's like passing the baton. So this minus the court part, minus getting the attorney part, minus all the extra stuff. There's no contesting. Wow. Why there's no contesting? Because I already was managing it myself, so I already knew how I was going to set it up. Okay, there was already a trustee.
I love this. So okay, if you want to be like sort of, kind of, maybe a little prepared, you do a will. If you want to be a little bit more prepared and have kind of an idea, you make sure your deed is right. But if you want to be 100% on point and with your game, you're doing a full living.
And not just on point, you're saving your family thousands of dollars.
Thousands.
You're saving your family money, because if something happens to you, like, I feel like that's the most important part. Forget the prepared part. It's the saving your family money and time. Because to probate, don't forget, probate costs money, and you have to hire an attorney. Attorneys are charging $300-400 an hour.
Is that out of pocket fees before they even?
Yeah. Where are you getting the money from? You can't go into the bank account of the person who's passed away. You don't have access. So you gotta get this money out of your. You have to use your money, and then after that,
Who's doing that?
Exactly. The family has to, and this is why family usually lets the properties go and they let the stuff go, because where are they getting the money from? You just paid for an expensive funeral. Exactly. You had life insurance. If you didn't, you just paid for expensive funeral, all these expenses, and now you have to pay for an attorney. It's a lot. So it's too much. We already, so you're avoiding your family having to go through this. On top of that, it takes time. This is a process. Probate process is 6 months, 9 months, a year, 2 years. The courts move slow. COVID, the courts move even more slow. So you're looking at time, privacy. Probate court is public record. So all your assets are out, who you're leaving stuff is out, your stuff. So now your trust, everything is private. Who's beneficiaries to what is private. What properties you had, what you had, and your assets are private. So there's a lot of different benefits to it, as well as some tax benefits and things. The irrevocable trust, it becomes irrevocable once you pass away. It's revocable while you're alive. It becomes irrevocable once you pass away. So if you're leaving stuff for your children and things like that, say for instance, a lot of people who work in high liability jobs, doctors and stuff, they put a lot of assets that they're leaving to their children in irrevocable trust, so creditors can't get to it.
Okay.
So there's benefits. There's a lot of stuff that the people know. They don't share with everybody.
No one's sharing this stuff. Where is this information?
So yes, when you're putting certain assets in irrevocable trust, you're not the owner of it anymore. You're not the one who's the trustee and managing it anymore. So creditors and people can't get to it. Yes,
untouchable funding.
Untouchable, yeah. Because it's already passed on. The revocable is still in your management and you're still the owner. But once it's irrevocable, you've passed it on already. So it's not yours to touch, and it's not for any creditors that may be trying to come after you to touch either. So against any divorces that they may have going on, any spouses that may be trying to come after them as well, you know, so it protects against a lot of different things.
Okay.
So there's ways that, you know, the world around us has been functioning that our community hasn't known about.
Just didn't know.
We didn't know. It's important that we use these tools up front now and avoid, you know, the issues later on. So
this just saves the family, like you said, just so much time just to understand what this process is, having the knowledge. This is, you shared so many eye-opening things just now. Like, I know we're gonna have to have a second chat. Like,
no, listen. And it's so personal to me because my last year my mom passed away. And I remember for like a year before that, she had always been saying, you know, put the house under your name, put the house in your name. I was like, yes, Mom, I'll have time, I'll put the house. And I still myself have been going through a probate issue, for like a year. So and that's why it's so personal to me, because I'm like, as an attorney, I shouldn't be doing this. And I have I'm personally having to go through it because I did not pay attention when she was telling me to just do that. And what would it have taken me to take, you know, 20 minutes to write a deed and have it recorded and do anything? And because I was just like, okay, Mom, we'll get around to it. And one day I didn't get around to it. And now and it just happened. You know what I mean? And now you see this with like COVID, everything just changed in a day. They were like locked down, and we're like, wait, what? You know what I mean? So and you know, and it costs time, it takes money, and you know, so and things don't move as quickly. So you know, it's better for us to prepare now, and it's just easier for us to prepare now. Thank goodness I have enough knowledge to know like how not to lose a property. But anybody else, they would have just been like, well, I don't know.
You would have just walked away. Like, this is what you just described. It's an overwhelming process if you don't have someone like you to teach exactly what's going on
all the time. And you'll see, and listen, there's people out there who are looking for these types of deals. They're looking for people, you know, in their early 30s, 20s, you know, early 40s, who don't know what's going on, whose parents have just left them a house or grandparents left them a house, and they just don't know what to do, and they're like predatoring, and they'll come and they'll be like, hey, I'll give you $10,000, just sign the deed, let me have this house. And they're like waiting for these deals to come about because they know people are not like understanding, and the best way to build wealth is property. When you own a home and you own a piece of land, like there's nothing more stable and more, you know, and a better vehicle for building your wealth and stuff. And you know, so it's so important.
Wow. Well, Sarah, please share with everyone, how can anyone, if they have more questions, want to reach out to you, what's the best way to contact you?
So there's a couple ways to contact me. Everybody can definitely go ahead and follow me on Facebook and Instagram at Bertrand Law Group. They can also email me if they have any questions, Sarah, SARH at bertrandlawgroup.com. They can also call me or text me, 305-206-0300. I am like, which I would like to call a modern law firm. So we don't have the normal regular business hours. So we are, I'm not going to say 24/7. However, we are flexible on our hours. So if you call, we do answer after hours, and we are open to texting and emailing. So we're pretty flexible on that. And we work on the weekends and things like that. So
modern world, I love it. You're accessible. Questions can be
very
asked.
accessible.
Excellent. Everyone, thank you so much for joining and watching. Again, I'm Jemea Kingsby at @MiaMiami_real estate. I am with the Howland Group at Compass in South Florida. And always feel free to DM or reach out to me directly at 786-328-0335. And until next time, everyone, take care. Bye-bye.